welcome everyone to CCI's first national webinar. And our topic today is COVID-19 and how to deal with this crisis in your condo. My name is Sonja Hodis. I'm a condo lawyer and a director on the CCI Huronia Board of Directors, and I will be your moderator tonight. While COVID-19 has caused us as a society and condos specifically to adapt quickly to ever-changing times, one thing that has had a great impact on us as humans is the requirement to maintain safe social distancing. And as condos are communities and those involved with condos are usually quite social, this makes social distancing difficult. So for some good news tonight, while you can't travel to all the amazing parts of the country right now, we are going to bring a little piece of every part of this country to you. And the good news also is that you're not going to have to keep 6 feet away from your monitor. So let's get close and connected. Tonight we have a great lineup of speakers representing each of CCI's chapters from coast to coast who are going to share their insights and experience. So we're not in the same room, but we are still connected, and CCI is still your condo connection. Who is CCI? Well, CCI is the Canadian Condominium Institute. We are an independent nonprofit organization that was formed in 1982. Our main objective is education. However, we also advocate for condominiums and the condo industry in general. We represent all those involved in condos, from owners to directors to professionals, and we encourage all stakeholders to work together. One of our main assets is the fact that we have access to a variety of professionals, owners, and directors from coast to coast, as we are the only national condominium organization. If you're not a member of CCI and you want to experience the benefits of membership, check out one of your local chapters today. There's going to be a post in the chat box with a link to find a chapter near you, or you can go to our national website, cci.ca. In addition, CCI has collected numerous resources on COVID-19, and they can be found on the National Resource Center at www.cci.ca. Great place to check out some of the resources that people from various chapters across the country have posted. Just a reminder that tonight's webinar will be recorded and it will be available on the Resource Center shortly. Before we get started, just a couple of reminders. Please make sure you keep your phones muted and that you mute your mics and shut off your cameras. Please don't turn them on during the webinar. We are recording the webinar and we're trying to get the best recording possible so that those that are not here tonight can view it at a later date. If you're having any trouble with your connection, you may want to try ending the meeting and logging in again. And also, we are not taking any questions live during the webinar, but there is a chat box function that you can find if you just scroll your mouse over the screen. On some computers, it'll be at the bottom of the page, some computers at the top. It looks like a little thought bubble. If you click on the chat button, you'll have a screen pop up where you can type in your question. We do have people moderating the chat box. The speakers will be moderating the chat box, and we'll try and answer your questions there. And before we get started, we just need to make sure that everyone understands that the information that is provided today is general information. And since things are changing fast and what you should be doing in your specific situation is very fact specific, it's more important than ever that condos rely on their professionals for advice in these challenging times. As a director, some legislation across the country provides protection if you rely on professional advice. I just want to remind everybody that tonight's webinar is not intended to provide you with opinions that would protect you under this type of legislation, as the information is general in nature and doesn't take into account your specific fact situation. Also, for those that are viewing this webinar after today's date, I just want to make sure everyone understands that the information provided in today's webinar is current as of May 7th, 2020. Things are changing rapidly, and the information provided today may not be relevant or applicable at a future date. And also be advised that since we do have speakers from across the country, references to legislation may not be a specific reference to the legislation in your province. As such, it's important that you consult with your local professionals to ensure that you're getting the right advice in relation to your province and your specific fact situation. All right, so let's get started with our first speaker, who is Anand Sharma, and he is a property manager from Alberta, and he's going to talk to us about one of the topics that are always on the front minds of condos, and that is cash flow, practical considerations. Anand? Oh,
Okay.
so,
I'm
there you
now
go.
unmuted.
Sorry,
There we
trying to
go.
unmute you. Go ahead.
Great to see everybody out there, and welcome from sunny Edmonton, talking about cash flow practical considerations. So a lot of condominium boards and managers already engage in cash flow exercises on a monthly basis. When you review your financials, you're doing that. Management companies will often make sure that you can pay the bills. But why do we need to take extra steps at this point to manage our cash flow? Well, obviously, this unprecedented COVID crisis has had some unintended consequences for us. Obviously, for condo corporations, our primary revenue source is condominium contributions from owners, and that is being impacted with the economic impact of this crisis, this healthcare crisis. So from our perspective, absolutely monitoring cash flow outside of our regular means of how we do it is really important to monitor the inflow and outflow of cash, and making sure that you can complete some of the things that you need to do as a condo corporation. So boards cannot currently, and it'll be talked about later by my colleagues, cannot necessarily rely on courts during this time to enforce and ensure that funds are being paid for owners. So it's really important that you do modeling that takes into account individuals and their inability to pay and defaulting when you're looking at what projects you should do. So I've kind of broken it down in this way. The first exercise that you should be doing is going through all of your anticipated expenses and really ranking them via priority. So high, medium, low, numerical system, however it works for you, you should do it. And that should be the first kind of exercise prior to going through a new document. If you don't already have it, generally speaking, 2 to 3 times your monthly revenue should be in your operating account. Some have already had that from before, but if you don't, or if you've been impacted by, say, extremely high insurance premiums that you didn't anticipate this year, that revenue might be quite low. So knowing that you had that built up or not is important. And some other things that, like I mentioned, factoring and default rates, that's going to be ongoing and changing. Whether, April, people were not expecting as much default in terms of people not paying their condo fees, but we're starting to see in May and June, depending on where you are in the country, those rates may go up. In May, certainly there has been a little bit bump up for some condo corporations. Factoring that into your cash flow document is really critical and important. And also factoring payment plans and how they impact your cash flow. So if you've allowed somebody to pay their condo fees over 6 months because of the COVID crisis, make sure you factor that in to your calculation. Suspending your reserve contributions from operating on an annual basis or a monthly basis, that is something that some condo corporations are doing. It doesn't mean that they're not going to make that contribution, but they're not going to make it on that monthly basis. That's a discussion your boards need to have immediately. And you should also communicate that out to your owners as well, that has been done. There should also be a communication piece out to people, and basically your cash flow you need to be monitoring on at least a monthly basis. If all else fails and you've not made those contributions to your reserve, and you've done all these exercises that are things that I've talked about, you may have to special assess the owners to ensure that there's cash flow. And that's not where you want to necessarily go, but that is a last resource as well. And I think Maria is going to talk about this. Financing as an option is possible. I know that CWB Maxim has put out a program around short-term financing, and that may be a last resort for you. But this is a critical thing that condo corporations and managers and boards need to do now. If you're not doing it now, you could find yourself in some significant difficulties. And remember, this could be a crisis that we have coming in waves. So even though we may have a short period that we're doing this now, consider doing this in the long term. So, all right, so that's a real Coles Notes high level discussion about cash flow.
Thanks, Anand. All right, so moving from cash flow to liens and whether we should lien or not, we've got Devin Cassidy, who's a lawyer from Nova Scotia. Devin, what is the answer to that question?
So the answer would be, it's in your legislation. So I've got some general comments to give you guys an idea about when we should be looking to lien, but you're gonna need to go back to your legislation because some of the rules do change from province to province. So the first thing is, what is a lien? So here's the fancy lawyer answer. It is a registered legal claim against an asset, such as a condominium unit, which is used as security for a debt owed. What that basically means is it's a document you're recording on the title of a unit that is securing the money owed by the condominium corporation. The security basically guarantees the debt and uses the unit as a collateral. And what it's doing is it's decreasing the risk of a lender. And in this situation where you're in arrears or the condo corp is owed money, the condo corp is basically a lender. The type of interests or fees that you can secure on a lien would be any unpaid common element fees, condo fees, a special assessment, and typically any amount of money that is owed to the corporation by an owner. But again, double check with your legislation to get the full list for your province. The lien amount is going to cover what's owed, it's going to cover interest, and it's going to cover costs such as legal fees or disbursements. The costs that are included are going to be outlined in your legislation. Some provinces cap what can be charged, and some use the word reasonable in respect of what that actual amount would be. When your guys are recording it, the thing that makes the lien so powerful is something called priority. And what priority means is that you, the condo fees, will get paid out before something else that is owing or charged on the unit. So for example, in most provinces, condo fees will be paid out before mortgage fees are paid out, which is a very big power because mortgages typically tend to be higher, and also gives you something as a corporation's lawyer or property manager to negotiate with a mortgage company in order to get paid. Some provinces allow the declaration to dictate priority. Some provinces have no priority at all, such as Prince Edward Island. And in Nova Scotia, fun fact, our power bill ranks above our condo fees. But all of this is specifically in your legislation. When you're looking at what to do if you want to record a lien, before we even get into whether or not you should, the first thing is have someone draft it, typically legal counsel. Then you're going to need it recorded. You're going to need notice to go to the unit owner so they know there's a lien on their unit. And then you need to take steps to either receive payment or enforce it. The way you get back this money from a lien is either it gets paid out on a sale. You can go to the mortgage company, as I mentioned, to negotiate. Alberta specifically states in their legislation that you can actually add that money, that a mortgage company can add that money to the mortgage and then recoup from the owner, which is a great power for condominium corporations to get that money back. And the other thing you can do is go to foreclosure, which is the same way you would enforce a mortgage debt. As Anand mentioned, that's difficult to do in the current situation where courts are closed, but it is always a remedy at the end. The question of to lien or not to lien comes down to timing. Many provinces require you to register a lien within 3 months from the first default. So in that situation, you don't have as much flexibility. You probably should send an email or a letter reminding the owner that they're in arrears, and then you're going to be quickly moving to get the lien in place. In other provinces, such as Nova Scotia, we don't have a time limit. So while you are recommended to put a lien in quickly after knowing that there's a default, in provinces without a time limit, you have some flexibility to debate whether or not the cost of the money owing is worth the cost of the lien, or maybe to give people a break. But in those provinces where their time limit is, irrespective of how nice you wish to be, there really isn't an ability to negotiate with the owner. You need that lien in place before the time limit expires. So make sure you check your legislation, speak to legal counsel to ensure that you're protecting the rights of the owners and of the corporation. Because again, as a board, you have a fiduciary duty to protect the interests of the condominium, which includes recouping funds, even in such extreme situations. 3 minutes, 59 seconds, done.
Thanks, Devin. Yeah, that priority interest is so important to protect. It's so unique to so many condominiums. All right, so some condominiums are feeling the pinch and trying to figure out where they can find some money. So we have Maria Durden, who is a condo lawyer from the Golden Horseshoe chapter, that's going to talk to us about some financing options and considerations that condos can think about and look into to try and help them get through this period. Maria?
Sure, thank you so much, Sonja, and hello from Ontario. So yes, some condos may be experiencing financial hardship at this time, specifically cash flow issues because of the COVID-19 pandemic for a variety of reasons, maybe increased maintenance costs because of additional cleaning, common element areas, supplies and services, or additional security personnel to manage visitors coming in and out of the building, or perhaps owners are simply unable to meet the demand of paying the common element fees because they've been laid off, or perhaps their income has been decreased for whatever reason. Owners are still required to pay common element fees at this time, and condos should be taking steps to ensure their lien rights are protected, as Devin mentioned. But condos do have options. They should be discussing these options with their property manager with the assistance of their legal counsel and other professionals, as the options depend on the condominium's governing documents and applicable legislation, which is very different from condo to condo and even from province to province. So keeping in mind that condos need to ensure that whatever steps they take comply with their specific governing documents, for example, borrowing bylaws or organizational bylaws, and applicable legislation, some of the options would include, as previously mentioned, working with the reserve fund provider to determine if it is appropriate to perhaps decrease or revise the reserve fund contributions being allocated to the reserve fund for a period of time. And perhaps with your property manager to review the operating budget to see if perhaps there's some budget items that could be reviewed and if all of them are necessary at this time. Again, both would have specific requirements depending on your organizational bylaw of your condo as well as your legislation, which may include giving owners notice and perhaps any other requirements. There's also another option, that's obtaining short-term financing. We're seeing some lenders out there providing short-term financing to condominiums. Short-term defined usually a couple months or perhaps a year or two. And again, it depends on the province that you're in and your governing documents of what you need to obtain that financing. In Ontario in specific, it's generally accepted and it's also supported by case law that a condo may borrow funds if the expenditure, so whatever item you're borrowing that money for, is listed in the condo's budget. And the condo has a general borrowing bylaw authorizing the short-term financing for that current fiscal year. Otherwise, if you don't have a general borrowing bylaw, and if it's not listed in your budget, then the corporation would have to pass a specific borrowing bylaw, which may be difficult at this time considering the COVID-19 pandemic situation. So yes, there are options. However, condos should be definitely be consulting with their managers, their professionals, their lawyers to make sure that what options are available to their specific condo because of whatever bylaws they may have in place, but also what the legislation allows in your area to make sure that whatever decisions you make are in compliance with the law.
Thanks, Maria. And so moving on to one more financial topic, and this is a question that we get a lot of, is what do you do with your contracts and your payment obligations if the contracts can't be fulfilled? And we're fortunate tonight to have Doug Forbes with us, who is a condo lawyer from Manitoba. Doug, what do we do?
Well, thanks, Sonja. So I'm going to talk about contracts and what happens if you're dealing with somebody who wants to get out of their contract with you, or what if you want to get out of your contract. So I'm going to cover some non-legal issues and then something called a force majeure clause. Also, sometimes in some financing contracts, it's similar to a material adverse change clause. And then I'm going to talk about what happens if your contract doesn't have that fancy clause. And then I'm also just sum up with some things that you should do now. So on the non-legal front, take a look at the relationship that you have with the person who's providing the, or you have the contract with. Is it a relationship that you want to preserve? It may be that there's a host of reasons for doing it. It might be that you want this relationship to be preserved for when you get out of the COVID experience, and we're seeing economies opening up. And it may be a situation where you need them down the road, or it may be for something like reputation. You don't want to be known as the condo that fires the contractors and treats them poorly. You don't want that, and especially in smaller communities, you don't want that getting around. If you do want to preserve the relationship, then look at what you can do. Reach out, talk to the person, see if there's anything that can be done. Can there be something, can you be doing advanced cleaning, purchasing PPE equipment? Can you isolate the work being done? Is there, if it's providing something, is there alternate sources of material that's needed? Can the payment terms be renegotiated? Can the contract be moved to another date? Can you just do part of it now and part of it later? It's time to start thinking out of the box and build some goodwill with the people that you conduct business with. If that's not a possibility, though, then one of the things that you can look at is something called a force majeure clause, and I think that was posted, and it's a boring clause that's in the fine print of a lot of contracts that everybody has until now disregarded and normally isn't read. But now everybody's reading it. Sometimes some people call them an acts of God clause, but it usually covers more than acts of God. It can cover all sorts of things. So the question is, can you use this to get out of a contract, or can somebody use it on you? And the answer from a lawyer is it depends. It depends on the wording, and it depends on the circumstances you're applying the wording to. You need to take a look at the clause and you need to see whether or not it fits your current situation. So I would recommend that you speak with your lawyer and you get some help in interpreting it and seeing whether or not it's worthwhile invoking it, or whether somebody has wrongly invoked it against you. When somebody looks at it, when I look at it, for example, I look at a number of 4 main things. Was the event foreseeable? Did you know it was coming down the pipe? If you try to rely on this clause and you entered into it in April, it's not going to work because COVID was foreseeable, of course. Is it in direct contravention to some other statute or in a public health order? If that's the case, then obviously you're not going to be able to perform the contract. You're either going to get out of the force majeure or with the doctrine of frustration, which I'll get at a bit later. If the wording of it, I mean, if it talks only about labor shortages, then you're probably not going to rely on it. But if you see wording like pandemic or general wording like acts of God, then you might be all right. And then finally, mitigation, and this is key. And it has, what can you do, or have you taken reasonable steps to perform the contract or to fulfill your part of the bargain? It would be the court would be unlikely to uphold use of a force majeure clause if you just went, oh, I can't do anything, I'm out of here. You've got to show that you at least tried, or at least thought about trying if there was nothing to try. So that's one way that people are getting out of contracts or finding that people are trying to use that on them. There's other clauses in contracts. I don't have time to get into them, but look at things like termination rights, liability caps, whether or not there's notice provisions that you have to give, all that sort of stuff. Each contract is different. So what if there's no force majeure clause? If there's no force majeure clause, then there's something called the doctrine of frustration, which is like a force majeure clause, except it's not in the contract. Speak with your lawyer. It's tougher to use, but a lot of the same considerations go into place there. So, and then finally, what should you do now? I would take the time to, before a problem presents itself, go through all your contracts now with your suppliers, with your maintenance people, your lawn care, whatever. Make sure that you understand what is there. If somebody tried to get out of the contract with you, or you want to get out of the contract with them, what do you have to do, and all that. Consider all reasonable mitigation steps. Looking forward, is there something else you can do in order to get the same services or to get the same products and that sort of thing. And then as much as possible, have the conversations with the people that you're in contracts with and talk to them about do they foresee a problem coming up? What can be done in order to deal with those problems, that sort of thing. So with that, I'm over my time. Thank you very much, and goodbye from Manitoba.
Thanks, Doug. You make a good point. It's not always about money. Relationships are such an important thing, especially in condos. So thank you for those insights. So moving away from finances to another topic, which is a big issue in our COVID discussions from day to day, is social distancing. And tonight we have Sue Duncan from our Northwestern Ontario chapter up in Thunder Bay to talk to us about social distancing and self-isolation. How do you get people to comply? And she's been dealing with this on the front lines because she's a property manager. So Sue, how do you get people to comply with that social distancing?
Thanks, Sonia. It's a bit of a challenge. Most people, I find are very compliant, but you get the odd person that wants to be defiant. We found that in the end of March, when most of the people, the snowbirds were coming home from the warmer climates, most people did do the 14 days of quarantine and did their self-isolation, but some chose not to. So the first thing that we did, we make a friendly phone call to them and remind them of the importance of isolating and complying with the regulations. And if they didn't do the compliance, then we would send a letter to them from the board of directors and management requesting their cooperation, advising the importance of isolating to keep everybody safe and healthy in a multi-residential setting. Failing that, if they refused to cooperate, we got the district health unit involved, who would pay a visit, well, first make a phone call, then paid a visit to the unit, and failing that would send a letter to the individual outlining what the potentials for fines are. We did have one particular case where an individual chose to have parties in their unit with 8 to 10 people in about a 700 square foot unit. We first contacted the police. The police did take an incident report and provide us with an incident number, but never actually did contact the individual. So then we contacted the health unit, and they did pay a visit to this individual, and then followed up with a letter outlining, the potentials for fines. And then with the same individual, in one of the common rooms that was large enough, a board member and myself met with him and discussed the seriousness of his actions. And so far now he has been complying, but that's been a challenge. There are certain people, most, like I said, 90% of the people do comply, but some choose not to. So, but the health unit was our biggest asset.
Yeah, sometimes reaching out to other agencies may help the condo deal with these issues. So thanks, Sue, for those tips.
Thanks.
So something that a lot of condos were dealing with immediately once sort of the crackdown on the restrictions came into place was, what do you do with visitors and contractors, and can you restrict them access to the property? And now that some provinces are slowly starting to lift the restrictions, the question really still is in people's minds about, can we restrict access to visitors and contractors? So we have Michelle Kelly, who is a lawyer from our Grand River chapter, who's going to tell us about what we should be doing in terms of restricting access. Michelle?
Thank you. So just a couple of preliminary things. I am in Ontario, so I'm familiar most with the legislation there. That said, I have tried to keep it fairly general. And the other thing to keep in mind, most of my comments will likely apply to high-rise condos as opposed to other types. So keep that in mind when we're talking about restricting access. The first thing I want to talk about briefly is that I think we would all agree from province territory that there is a general ability of corporations to generally restrict access. You see that with keys, fobs, security systems, that sort of thing. So I think that's where, to me, the starting point is. There already is a recognition that there is some authority to do that. Where the disagreement tends to come up is to what extent that applies in the current pandemic and whether you physically prevent people from coming to visit. So I'll talk about where the disagreement is when I get there, but I think I'll talk about the points where most people agree to start. So with respect to contractors, again, Ontario focused here, but the orders that have been made are fairly clear that there are very limited types of work that can be done right now in units. It depends a little bit on when the work started. So if an owner comes to you this week and says, I want to start renovations, I want to paint, I want to reno my kitchen, that's something that would be clearly prohibited. If it started prior to April 4th, then they may be able to continue to do that. You have to sort of get legal advice. The wording is not perfectly clear in every aspect. The other thing I like to remind people of, don't prohibit necessary essential repairs. So if an owner has a pipe burst, don't tell them they need to wait for weeks to fix that. You obviously want something like that dealt with pretty quickly, especially in a high rise where it's just going to funnel down and wreck several units. I think the key thing for dealing with the contractors is just to communicate with the owners. some owners they're just not aware of the orders. They think that they can paint in their unit. They think they can have contractors in to do the carpets, things like that. So they're often surprised to find out that's not really the case right now. So I think the first advice for me is just make sure you're communicating with people. This is a new situation for all of us. You know, try to keep that in mind. As far as how do you enforce when contractors are coming in, I think, again, you're going to get legal advice. Public health, police officers can be a valuable resource. If that doesn't work for some reason, then you're talking probably an urgent application depending on the circumstances and, again, the province or territory. The second part, though, that I wanted to talk about briefly is with respect to visitors, and I think that's probably where more of the disagreement is. Again, I think everyone agrees that you can ask people not to invite non-essential people over, you know, family members who are just there to gather and visit. It was a concern around Easter, I know, for many. You know, are you prohibiting people from getting deliveries for groceries, for medicine? Not probably wise to do that. You know, I do have condos that are physically prohibiting people from entering. Not 100% sure on the legalities on that one. They've sort of said, you know what, we have an average age 75 plus. We have several people who are immune compromised. We think the risks of allowing someone to come in and infect all those people outweigh the risks of prohibiting entry. So they're making people stop at the door and the residents come down and get their deliveries. So we'll see how that works out, I guess. But the takeaway for me, again, just communicate. I don't think a corporation is going to be in trouble if they're taking some of these steps. They're acting in good faith. It's well-intentioned. They're just trying to do what's best for everybody. I think the courts will recognize that this is a novel situation and, you know, we don't have the answers for everything when it comes to what you can and can't do.
Thanks, Michelle. One of the things that condos have been doing, or some condos have been doing, is collecting information when people come into the condo and asking questions. So this raises the question about what do we do with this information? Does it raise privacy concerns? And we have Jamie Hurl, who is a lawyer in Saskatchewan, from the North Saskatchewan chapter, here to talk to us about what we should do with this information that we're collecting. Jamie?
Good afternoon, everyone. So sometimes less is better. And in a situation like this, sometimes you will come into information that you may not actually want to know, because now that you know it, the corporation has a positive obligation to deal with the information you received. However, that's not my question right now. My question is, what do we do with that information? So does the condo corporation have a positive duty to inform other owners if an owner or resident self-identifies as having the virus, or in the circumstance that we had here in one of our condos in Saskatoon, actually passes away in the unit from COVID? Okay, so looking at that, you have to keep in mind that this information that the board has gotten is confidential health information, like any other health information that may be given to the board. And unless that owner or resident specifically gives you the green light, and that for me would be in writing and very clearly states that you can disclose that information, you cannot disclose that unit 303 or this person has that information. That would be a breach of privacy. You follow health regulations. You may want to say, we are aware of a case or a potential case in our complex. And again, you know your residents and your owners better than anybody else. So you have to judge what you do, because if you're going to have a million questions about who is this, and you're going to be inundated with stuff that you can't answer. But the more important thing is once you're aware of that information, that you then take that, you do a letter or a notice to the person in that unit, ensuring that, number one, they stay self-isolated, they follow the health rules, and that you've taken steps to ensure your liability is minimized. However, like I say, disclosing that information, I would not disclose any specific information. There is a very, very large stigma attached to having COVID. And sometimes the stigma and the fallout from people is bigger than being identified. So you have to respect the privacy that comes along with it. Sure, you can ask for if they want to be disclosed or if they want to have that information shared. But again, without something in writing authorizing you to disclose that to other people, you cannot identify, in my view, those people.
Oh, Sonja, you're still muted.
No, thank you. So thank you, Jamie. Before we go on to our next speaker, we are going to do a poll and get some audience participation. And so I'm going to launch this poll so that you can see the questions. You'll have an opportunity to pick your answer, and then we'll talk about the results after our next speaker. So the questions on this poll relate to what you're going to be doing with your AGM during the COVID crisis. And for the purposes of the recording, I'm just going to read the questions. The first one, is your condo going to hold a virtual AGM while the emergency orders are still in place? Second question, is your condo going to use electronic voting at an AGM while emergency orders are still in place? And the third question is your condo going to postpone the AGM until after the emergency orders cease and you're going to hold your AGM in person? So we've got quite a bit of a response going. I'll let that go on, and we'll move on to Nancy Houle, who is a condominium lawyer in Ottawa with our Eastern Ontario chapter, and she is going to talk to us about virtual meetings and electronic voting and some practical considerations. Nancy?
Great, thank you, Sonja. And I'll say hello from Quebec, but talking on behalf of Eastern Ontario. And for John and Justin, here's another fun fact from a lawyer. There is no one-size-fits-all for virtual meetings or electronic voting. Over the next few years, I'm sure we're going to see a whole variety of processes evolving. We'll also see virtual and electronic meetings being used even more frequently, even when large gatherings become the new normal. So from my perspective, I think here are 10 practical tips to be considering. Number one, make sure that your condominium corporation is legally permitted to have a virtual meeting and or conduct electronic voting. In other words, the first question to consider is if this is allowed in your jurisdiction. If yes, how is it allowed and for how long? Some jurisdictions have emergency orders in place to temporarily permit virtual and electronic meetings, others don't. Some jurisdictions allow for virtual or electronic meetings generally without emergency orders in place, either in the legislation or itself, or by allowing condominium corporations to pass bylaws to permit such meeting and voting practices. Just make sure you understand what is or is not permitted in your jurisdiction. Number two, remember, virtual meetings and electronic voting are not the same thing. So make sure that you're legally permitted to do both, allowing for participation and attendance virtually and allowing for voting electronically. Number three, should the meeting be held virtually? Consider what business you absolutely do need to transact at the meeting, what must be accomplished at a meeting. For example, in some jurisdictions, the annual budget must be approved at the AGM, can only be done once. So this arguably must be done. A virtual meeting is necessary. In other jurisdictions, certain meetings such as AGMs are permitted to be both postponed. What makes the most sense for your condominium community? Number four, and on the same vein, should a meeting be postponed, subject to changes in circumstances with the pandemic until such time as a large gathering can be held? New controversial issues that really can wait. Maybe it makes sense to wait for now until a fulsome discussion in person can be held. Number five, procedure is crucial. Be sure to follow all of the generally mandated process to ensure your virtual meeting is validly called. Follow the requirements of your jurisdiction for notices, pre-notices, proxies, etc. Number six, participation is necessary. Ensure alternate methods of participation for those owners who do not have access to a computer. For example, the ability to still mail in a proxy combined with attending the virtual meeting by telephone. Number seven, communication is key. Make sure all of your notices to your owners let people know exactly how they can participate in the various forms. Number eight, the validity of your meeting cannot be lost. For whatever forum you choose for your virtual meeting, your goal must be to make every effort to mimic an in-person meeting. You need to be confident that you can validate your registration and attendance, validate that there is no duplication of proxies or attendance, validate the voting process, allow for motions and votes from the floor, and allow for questions and answers. Number 9, book everything and everyone early. If you're using a third-party service provider, they're booking up fast and they have a limit on how many meetings can be done in one evening. There's going to be a lot of catch-up going on, so make sure you're prepared. Number 10, do a dress rehearsal involving the hosts, the board members, and who else will be playing a key role in your meeting so that everyone is comfortable with the technology that will be used during your meeting. And then sit back, enjoy your meeting, and continue learning about all of these fabulous tools that are at our disposal.
Thanks, Nancy. I can't believe you did 10 in 4 minutes. That's amazing. All right, so let's see the results of the poll. I'm just going to share those results with everyone, and for the recording, in terms of whether people are going to hold a virtual AGM while the emergency orders are in place, 46% said no, 40% said they don't know, and 15% said yes. In terms of electronic voting during the emergency order, 47% said no, 41% said don't know, and 12% said yes, so pretty similar numbers. And then in terms of postponing your AGM and holding it in person, 51% said yes, 34% said don't know, and 15% said no. So it looks like there's going to be a shortage of venues probably in the near future. All right, well, thank you everyone for participating in that poll. And along the same lines of technology and how we've had to adapt during COVID to using new technology, we have Jim Allison from Vancouver, our Vancouver chapter, who's a property manager, and he's going to share his experiences about adjusting and using technology for a positive change during the pandemic and in the future. So Jim, what have you learned?
Well, first of all, I'm not a lawyer, and so I approach things a little differently, and I appreciate my colleagues who have spoken so far. It's been very interesting. So I'm going to talk about technology and what the changes have been for us in the property management industry and for our clients. It has provided us a way to deal with the day-to-day management of the condominium. We have been using technology for a while, but we may not recognize that we were. For example, many of your condos have websites and web portals for information sharing. Our day-to-day banking goes on virtually without us even thinking about it now with ATMs and online banking. We can now tap or use Apple Pay to pay for things. Ooh, that's tough. Who would have predicted how important tap would be to vendors during the current crisis? So when you go to a takeout restaurant, which is very popular here in British Columbia, as all our restaurants are basically closed, we have a way now of paying for the service safely, as there's no personal contact with it. Moving forward, though, there has been a fear with the older generation that we will not be able to participate in this new way of doing business. If they can Skype, and I think almost everybody wants to or does, then anyone can participate in a virtual meeting. With my clients, I've been successful in getting them to participate by explaining that a virtual meeting is Skype on steroids, and I offer them free one-on-one tutorials to ease their concerns. The pandemic has accelerated the acceptance of technology. We must now look forward to beyond COVID-19 and what will be the new normal. For those of us who chair meetings, we're learning how to use the best tools available on the different meeting platforms, be it Zoom or GoToMeeting or any other service. The more adept the chair is at using the technology, the more successful the meeting will be. For example, if you can show the agenda, report, financial statements on screen during the meeting, the participants will be more engaged. Having consultants and other professionals join the meeting is also possible. And in British Columbia, all owners have a right to attend all the meetings, so we can have them participate in the online meeting, but we can also have the power to mute them, which is the most important tool in our toolbox. And it is not just meeting. My office phone number rings on my cell phone and laptop. I can return calls from my office phone without being in the office. My office is my iPhone and my laptop. I can be anywhere, and who would know? Do I really need to have an office? Not really. I do need to have a back team behind me to support me through it all. Will we go back to the way things were? or will we continue to use the newfound technology to make things easier? I think we're going to continue to embrace the technology. And here are some thoughts I have. Once people try a virtual meeting, they really seem to like it. The meeting room can be anywhere at any time. There's no need to search for meeting locations, halls, wherever. And small condos who don't have meeting rooms are really finding this a good thing. In my experience, the meetings go faster. Everyone seems to be more engaged and more focused. In many cases, participants behave better. You don't seem to have the multiple conversations going on around the board meeting table. And being visual, being able to see the participants really enhances the meeting, more so than a conference call. You can actually see the body language, which for a chair of a meeting is very important. Board members and property managers can attend from anywhere. So if you're stuck at the office, you can still join the meeting. Recognizing that in most areas, the board meetings are at night, virtual meetings allow the property manager to have the meeting wherever it is best for him or her. In areas where there are weather challenges, never here in Vancouver, of course, this becomes even more important. With remote phones and the ability to have board meetings from anywhere, this will allow more time flexibility for property managers. And perhaps this will help reduce the turnover of property managers, which is a huge challenge in our condominium industry. We're still uncovering the challenges presented by COVID-19, and we will learn more of the challenges as we move forward. COVID-19 has provided us with this unique opportunity to embrace technology to enhance management and services to the condominium industry. So let's get at it. Thank you.
Thanks, Jim. All right, so moving on to a new topic area, health and safety. I want to introduce Laura Githrow, who's a lawyer from our London chapter, to talk about obligations to employees during COVID. Laura?
Thank you. So from a health and safety perspective, the specific laws vary between provinces, but each province has some version of occupational health and safety laws. Under these laws, condo and strata corporations, as well as property managers, have an obligation to provide a safe workplace for employees and all workers who are on the property. Corporations can face liability for failure to meet this obligation. In addition to this liability or potential liability, employees also have the right to refuse unsafe work. So on a very high level, you should ensure that all building staff, property managers, superintendents, security, concierge, cleaning personnel have been notified of the risks and hazards in the workplace regarding COVID-19. In addition to physical safety, it's also important to consider what you can do to support your employees' mental health. Employees are likely going to have a number of questions for you about attendance, sick leave, vacation cancellations, working remotely, pay and insurance coverage during this time. You should be prepared to answer these questions and address these topics with your team. As you know, not all employees can work remotely. So I trust that you've created a plan over the last several weeks to ensure that staff who must work on site are adequately protected while performing their duties. Now, as provinces are announcing their plans to reopen the economy and relax certain physical distancing restrictions that we've been talking about, I recommend that you review your policies that you have developed and implemented to deal with these new normal this new normal that we're going to all be experiencing as the economy reopens. For on-site staff, this could mean that the risks that they're facing day to day will change. There will be more opportunities for individuals to come into contact with the virus and bring it back to the property. In addition to the on-site staff, you're going to want to consider those staff who are working remotely, because staff who are working from home may want to come back into the office, and you may want to consider how and when that transition will happen. When you're reviewing those policies and making adjustments to deal with the reopening of the economy, It will be important to look at your local and provincial guidelines and their recommendations for workplace health and safety requirements. Ontario has released guidelines for businesses to ensure minimum health and safety requirements for employees. I have not seen any guidelines specific to multi-residential buildings, but there are general recommendations that have been presented for all employees within the province, as well as for employees in specific office environments and specific working industries. You should be reviewing these minimum health and safety recommendations in order to meet that statutory obligation that you have to provide a safe workplace. Each corporation is different and has unique needs and limited resources, but it's important to remember that your policies can be more restrictive than the provincial requirements, but you cannot be more permissive. There are certain things that need to happen to ensure employees are safe while they are at work, and you have that obligation to ensure that the workplace is safe for your staff.
Thanks, Laura. Now, switching from employees to an issue that I understand is becoming a big issue since everyone is now working at home and living at home full time. We're seeing a big increase in fires. So Michelle Farley from the Huronia chapter, a fire safety consultant, is going to talk to us about fire safety and directions from authorities across the country. Michelle?
Thank you. I'm here to explain fire safety and directions from authorities across the country during COVID-19. The provincial fire marshals and commissioners' offices are not giving direct instruction on how you are to implement the fire code in your condo at this time. Why is that? The fire code is the law, and officials are not going to instruct you to disobey the law. These are unprecedented times. Some provinces have far more active cases, which may limit condos' ability to conduct testing. Others may have multiple active cases in their area or in their building, raising concerns of in-suite access. You have to do all you can do to meet the fire code. We're safe to do so. We have seen a significant increase in home fires, up to 65% in some provinces, with the leading causes being smoking and cooking. So how do you keep both your people and your residents safe? The Canadian Fire Alarm Association, CFAA, a national organization, released guidelines in April stipulating that it may be reasonable to postpone in-suite testing. Testing is regulated by the national test standard CAN ULC S536, which you and your service providers follow for annual and monthly testing. May 5th, CFAA released a COVID-19 bulletin stating you must track who helped you make the decision to deviate from the fire code when postponing any testing. UL released a statement saying if circumstances prevent you from complying with the written requirements of the standard, you must document your alternate procedures, when the change went into effect, and when it will go out of practice. How do you differentiate and determine what's right in your building? There's 3 categories. If your condo is in Nova Scotia, Saskatchewan, Manitoba, or regions with low COVID numbers, you may not have to modify your fire code protocols at all. If your building is a resort or vacation community with limited occupancy, or a condo with limited or no COVID impact, you should be able to conduct all testing, including in-suite inspections. This is recommended in all buildings where feasible. In buildings with active COVID cases, you may only be able to test the common areas and some suites. For these cases, many service providers have developed safety protocols for in-suite testing under these circumstances and may help you to test the majority of your suites. In Ontario, Quebec, and regions with higher active COVID, it may only be reasonable to conduct your common area inspections and postpone all in-suite inspections. The annual test standard, 536, has a clause which allows for inaccessible devices. This clause could be used to postpone suite testing where residents are vulnerable or suites inaccessible due to COVID-19. Continue testing and maintenance of your life safety systems. Provide reminders to your residents about fire safety. Document any deviation from your fire safety plan or test standards. You may require a professional opinion to review your options. As a fire code consultant for more than 30 years, I'm advising my clients that there are no one-size-fits-all, but you may not be able to conduct in-suite testing during COVID-19. It's essential that you comply with the code, but you also have to consider the risks of going into suites. With more people home and fires on the rise, there has never been a more crucial time to ensure your building is safe. Where you can test, test. Where you can't, get advice. Keep records and communicate with your residents. Be reasonable, be informed, and be realistic. You're not alone. Reach out. We are here to help. Thank you.
Thanks, Michelle. And Michelle's given us 3 questions. We're going to launch our second poll. And these questions are all about fire safety. So go ahead and start answering those questions. I'm just going to read them for the recording. The first one is, are you doing your regular monthly or annual fire alarm life safety systems testing during COVID? Have you conducted your annual testing and included in-suite fire device testing during COVID? And the third question is, have you conducted your annual fire alarm life safety testing and excluded all in-suite testing during COVID? So we'll just let everybody take a few seconds here to answer the questions. And we'll see what the results are across the country. We're up to about 150 votes right now. Okay, numbers seem to be slowing down. Okay, we've got about 50% of people participating. So let's see what the results are. And there are the results in terms of whether people are doing their regular testing. 76% are saying yes. In terms of whether people are conducting annual testing, including in-suite testing, 82% say no. And in terms of whether people are doing testing but excluding the in-suite testing, 54% said no, 46% said yes. So that's almost pretty even there. Interesting statistics. All right, so we're going to now switch over to look at what one province in Canada has done with respect to ministerial orders. And we have Lori Kierdowski from the South Alberta chapter to talk to us about what happened in Alberta on April 9th. Lori?
On April 9th, our government, surprisingly and very quickly, put out a ministerial order that had various elements of that order that affect us in our condominium corporations. I'm going to touch on 4 of those that are quite germane to us. There are others, but the 4 that are the ones that we've seen repeated today in our discussions that are ongoing items of concern. First is the obligation to hold a turnover meeting for developers or to hold your annual general meeting, and here it's not less than every 15 months, or not more than every 15 months. We can't have more than that time elapsed. So the requirement to do that has been put on hold. However, we are being permitted to hold virtual AGMs, but we don't have legislation that addresses how you hold these virtual AGMs, nor do we have legislation that addresses the items like voting. And Nancy spoke about those particulars earlier. So it's quite difficult for us. Our advice has been that while this order has been put out, we should probably, in Alberta, unless you have bylaws that specifically address how you're going to deal with proxies, attendance, voting, those items that are of critical importance, and participation. Don't forget, not everybody has the ability to participate virtually in AGMs. And this is a fundamental right of a shareholder, is to participate in their annual general meeting. We're suggesting that you probably put them on hold. Next is the requirement to convene a special general meeting on requisition by owners has also been suspended. Our legislation specifically requires or specifically provides that if 15% of unit owners requisition a special general meeting, we are obligated to convene that meeting. So that has been put on hold. our advice on that is to use that. And indeed, just yesterday, I had a client who had received a requisition for a special general meeting. The purpose of the meeting was to remove the property management company and to replace the board of directors. And this was right on the tails of a special assessment for a makeup air unit. And I'm sure a lot of us have experienced these sorts of requests for general meetings when it's because owners are upset about something. So luckily we were able to rely upon that order. The condominium corporation is fairly small, 20 somewhat odd units, and the party purporting to requisition it was trying to do it in their unit and saying that people should bring their own PPE. So the letter's gone out. Maybe we'll have another one of these meetings in the future and I can tell you what happened. The next one that is relevant here is that the statutory right of entry into units in Alberta has now been suspended unless you're expressly or impliedly invited. If an occupant has symptoms, has COVID-19, or is self-isolating for any reason, or if the person purporting to enter has any of those, is any of those things. Our thoughts right now are that we're all self-isolating. We're still under a public health emergency mandated by our government, and we shouldn't be going in, save and except for emergency situations. So the fan coil units can wait for now. Floods, we need to go in. Danger to people and persons, we need to go in and deal with those things. But unless it's absolutely necessary, we're suggesting that you don't go in. Interesting enough, another things that happen in the field, we're trying to go in and deal with bed bugs in a particular project, and we're getting some flack on that. And we'll see how that plays out. I personally think that these pest control people probably have the PPE shtick down pat. So I'm not too worried about them bringing it to me, but people have different thoughts on this, and we know that sometimes people like to make waves. Just say it that way. Last one I'm going to talk about is that our reserve fund studies, plans, and reports, a requirement to provide them, that has too been put on hold indefinitely. Our question to our owners and our corporations is, if you can still conduct them safely and with appropriate social distancing, why wouldn't you continue with the work? The buildings don't recognize COVID-19. They are still aging, and the requirement is still going to need these reserve fund studies done. So go ahead. If you can do it with appropriate social distancing, it's one less thing that's going to be stacking up on us out the back end of this that we're going to need to deal with. Furthermore, if we keep people working in a safe way, this is devastating to people. If we can keep them working, go for it. And that's my top 4 for today. Thank you.
Thanks, Laurie. And I know a lot of provinces came after Alberta in terms of trying to address some issues for condos specifically, and some provinces haven't addressed those issues. So it'll be interesting to see what happens over the next couple of weeks if anybody else responds. So we've heard from lawyers, we've heard from property managers. Now let's turn the tables a little bit and let's talk to Donna Matthews, who is from the South Saskatchewan chapter, and she's going to talk to us from the perspective of a condo director and lessons that she's learned during the pandemic.
Hello from Moose Jaw. We have discussed succession in passing many times, but promptly went on to seemingly more important things. The daily updates on the corona status locally has made the what could happen much more real. All our border in the 50 to 73-year-old bracket. The importance of a succession plan is something to move to the top of the list. We're all volunteers and busy, but what if we got sick? Heaven forbid, what if we didn't survive? It changes the way one thinks. However, regardless of why, board members do burn out and leave, and then what would happen? You could end up with board members who aren't aligned with the vision for the community, board members who don't know precisely what their roles are, or even board members who may try to undo strides a previous board has made. They may not understand their fiduciary responsibility to their fellow unit owners and potentially jeopardize the financial well-being of this community. Succession planning ensures leadership continuity. To start the process, first create an exit strategy or your way out of the job that is based on your condo running smoothly without you. Identify current and future needs. What skills does your board possess? Where are the gaps? Some of this will be based on future projects in the community vision. A healthy board is always looking to the future, planning 3 to 5 years in advance. Define your critical roles and identify possible individuals. Who could take over right away? Is there someone now willing and capable, or someone who with a little bit of guidance would be great? People are sometimes scared of what they don't know. It is a board's responsibility to provide the information homeowners need to have about how things work within the board so that they're more willing to get involved. Determine who can fill such positions and identify the difference between their current skills and those needed in the future. Groom and pay attention to their training and development. Express gratitude. Saying thank you can go a long way. Those who volunteer know what a difference they are making. Provide the right education and information. Part of this would include ensuring a thorough understanding of the governing documents. Take a CCI director's course. In succession planning, it is one thing to pass along critical information and knowledge. It's another thing entirely to make sure that that person or the succession team builds the relationships they need for the future. Succession planning requires steps like mentoring to be successful. Set a path. No one should be expected to jump from volunteer to board president. It's necessary to lay groundwork for the future. A strategic succession plan will ensure the community culture is maintained and reduces stress on members during the transition. It also means the corporation retains knowledge, history, and business relationships. Our succession plan is a type of insurance which helps your condo corporation continue both now and in the future. We buy insurance to protect the corporation from hurricanes, floods, and fires. We install security systems to defend from theft. We back up data to safeguard our information. But many directors get so busy with the day-to-day, they fail to make succession planning a priority. We need to change that. Reevaluate. Plan can be a work in progress because as life changes, willingness and ability to fulfill roles change. Be flexible and review your plan occasionally to keep it current. Don't put it off just because it's not perfect. We need to start somewhere, and there's no better time than now.
Thanks, Donna. And that's great advice from a seasoned condo director. And, you know, we talk about succession planning from time to time, but we never actually get down to doing it. And it's situations like this which really force us into having to deal with it. So thanks for those thoughts. Now, to hear the perspective of a condo owner, we have David Cumming from Newfoundland, our Newfoundland chapter, to share his experience about living in a condo during COVID. David?
Hello, greetings from the Rock. I first noticed the impact of COVID-19 because a group of us owners got together every week, rain or shine, to go to a coffee shop and solve all the problems of the world. Well, the coffee shop shut down. And then all the coffee shops shut down. Well, one of my coffee buddies during Easter, she cooked us all a wonderful Easter dinner, set it down in front of our door, and we all enjoyed this Easter dinner. And at the end of the meal, we all went out on our own balconies and toasted our cook. But in terms of impact, the lady that was cleaning our building for many years discontinued that, and I'm not sure why, but I suspect she had kids in daycare, and that's not in Newfoundland an essential service. Cleaning a condo is not considered an essential service. So the corporation was required on very short notice to find a replacement cleaning contractor. That would always be an issue, but during a pandemic, when it's so important to keep your building so clean, that was a concern for everybody living in that building. The next impact I saw, fully 3/4 of all the infections in Newfoundland and Labrador could be traced to 2 funerals carried out at one funeral home in the city of St. John. Well, unfortunately, 2 of the people infected were Canada Post letter carriers, and they were sent off to self-isolation, and the mail delivery system was shut down in St. John's for a full week while they cleaned and disinfected the sorting facilities. And then it took another week since there was a backlog, to get mail delivery back up speed. And so that was an impact. All the owners were impacted in the city on that, but especially the seniors, because they seem to depend on male to liver more than most demographics. And the fourth thing I saw was 10 out of 16 of our owners are investors. They don't live in our building. In fact, 3 of them don't even live in our province, but they all have tenants here. And some of their tenants normally live in Europe. So as soon as the pandemic was declared, they left. They were worried about getting stranded in Canada. So this left some of our investor owners with a cash flow problem. And they petitioned the board for a deferred payment schedule because we had an assessment to be paid here to bring our reserve fund up to what it was supposed to be according to our reserve fund study. So the impact on some of our investor owners was an issue of complications to their finance. So those are the main issues that I could see from within my bubble in St. John's.
Thanks, David, and thanks for sharing those experiences. Who would have thought people would be missing their mail? There's usually just junk in it, but I guess it does become important when you don't have it. All right, so staying on the East Coast, we've got Judy Orr from our New Brunswick chapter, and she's a condo industry consultant, and she's going to talk about what she's learned during the pandemic in terms of what changes you should make to your governing documents. Judy?
Well, thanks, Sonja, and greetings from New Brunswick. So some of the amendments to the governing documents that will allow a condo corporation to respond to events such as our current state of emergency with COVID-19. I want to mention, first of all, keep in mind each province has its own act and governing documents. For example, in New Brunswick, in addition to the act, there's a declaration and a bylaw, which includes the rules for governing the common elements. But in other provinces, there may be a different configuration of documents. So where these proposed amendments could be added will vary. So here we go. Top 3 recommendations for amendments to your governing documents. Number 1, add permission to the governing documents to permit virtual meetings and electronic distribution of material. Virtual meetings for board of directors and virtual meetings for your AGMs. Allow electronic voting for both. And if not already included in the governing documents, add permission to get consent to distribute notices electronically, your AGM packages, your annual notice for condo fees, copies of the budget, whatever. Number 2, there may be a requirement for holding annual general meetings within a certain time frame. In some provinces, this may be in the provincial legislation, but in others, it may be in the act. It could be almost anywhere. In New Brunswick, the Act does not address this at all, but most of the bylaws we see do have a requirement where you have to hold an AGM every year and within 15 months from one year to the next. In a state of emergency declared by a government authority, and where we have a situation like we do today where large gatherings are suspended, how could we handle this? So I can think of 2 ways to handle it. You can either add permission to your governing documents that all AGMs can be suspended until the state of emergency is lifted, or you could add permission to hold the AGM as a virtual meeting. But virtual meetings require some careful preparation. Follow Nancy's tips. Ensure owners are able to attend. Remember, not everybody has a computer. Not everybody's comfortable accessing virtually. And also keep in mind that you still have to meet the requirements for your quorum. Number 3, add permission to cover the corporation's response to a state of emergency. This is to ensure not just compliance with the state of emergency, but safety, and also to avoid any liability for the corporation. If not included in the Act, it could be added to the condo corporation's own governing documents. Now, for this particular amendment, I'm recommending the use of a policy. And whether you include the full details of the policy in your governing documents, or you simply acknowledge that permission has been given for the corporation to create and update the policy, that might depend on which province you live in. It's acceptable in New Brunswick. Either way, the policy should include such things as how you're going to communicate with your residents, restrictions to visitors, whether or not you're going to close some of your facilities, the pool or the fitness room, What additional safety steps can be taken? Sanitizing high-touch areas or limiting the number of people in mailrooms and elevators. Whether or not you're going to allow renovations to continue, or are they going to be postponed? Guidelines for urgent repairs and maintenance. It's going to happen, but you might want to have some guidelines where you have a particular person, handyman or plumber, that you're going to use exclusively. Whether or not you're going to postpone deliveries and moving, or are you going to provide guidelines on how these activities can be managed carefully. And finally, you should include a recovery plan, including how restrictions are going to be eased. We've got lots of good examples of this as we see provinces across the country are building their own recovery plans. So this is not an exhaustive list by any means. It's just the main points to be considered for an emergency response policy if you plan to implement one. So these are 3 amendments that I feel would be useful to ensure that a condo has the ability to respond when a state of emergency is declared.
Thanks, Judy. And don't forget to make sure you check with your local professionals to see what you can do specifically in your province. Great ideas. All right, so the next topic is a great example of how things change from day to day and week to week during this COVID crisis. When we planned this webinar, in Ontario at least, landscaping was this big hot topic about what you could and couldn't do. And little and behold, things changed from one week to the next. But the interesting thing that Sean Doyle is going to talk to us about tonight, he's a property manager from our Windsor chapter, is regardless of what the legislation says is and is not essential, there are still certain things that you should be thinking about. So Sean, please enlighten us on this topic.
Thank you, Sonja. Yeah, so because our audience is from various provinces around the country and various municipalities, we're just not going to talk about the specifics as Sonja sort of said, but I do believe this topic is still important. And I'm glad that Doug Forbes and Sonja talked about relationships and goodwill, because I believe that that's important with all of our contractors. When you're dealing with the landscaping, for some of our landscapers, not only is insurance going up for owners, insurance is going up for our service providers as well. So if we don't have good relationships with our contractors, it could mean a negative for our condominiums. And sometimes you think, well, especially with landscaping, we may have pros and cons, and owners have different perspectives about how that landscaping is being taken care of. But the next landscaper waiting in line may not be necessarily that much better, and they might be much more expensive. So just to go over a couple of lists of things that you could consider that would be essential, that maybe should be continued, and things that would be non-essential. Cleaning up of debris and tree branches and landscaped areas to ensure that properties are safe and that there's no hazards for some of the residents. That could be considered essential. Obviously, grass cutting, we don't want the grass to get too long. We need to maintain some sanitary standards, so that would be essential. Tree trimming to ensure that nothing is going to fall and injure someone could be considered an essential service. And of course, the sprinkler startup, although you might not think that's essential, if we don't get those things going, when the provinces do start saying that you can start doing some of this work, you're going to be so far behind with your contractors that you at least need to get those started up. Even weed and feed can be considered essential so that you maintain the health and you don't run the risk of a lot of damage to the grass, and then the corporation has a huge bill to fix that or replace that. Some non-essential, of course, would be upgrades or improvements, aerating or dethatching or rolling of the lawns, and some of the pruning and things like that could be considered non-essential. You could sort of think about it as softscapes would be essential, and hardscapes theoretically would be non-essential. So in short, managers and boards should be ensuring that contractors are following social distancing when they are coming to your property. They should include things in their vehicles like disinfectants and hand sanitizers. They should be cleaning their equipment. They should be driving in separate vehicles when they're not from the same family. And they should have some sort of a protocol maybe worked out with the company, the landscaping company, and maybe in conjunction with the property manager or the board, how they're going to handle if they do come across another individual or an owner or a resident who's having a concern with them being that close. I think especially with townhome condominiums where they could be pretty close to someone's front door or front patio. So how they're going to deal with that. But I think at the end of the day, and I'm glad it was talked about earlier, is the relationship that you have with your contractors could be very negative if the relationship sours during this period, and then you run into those kind of concerns later on. So that's the brief description of what you could consider essential and what you could consider non-essential during this time. Thank you, Sonja.
Thanks, Sean. And you know, that word relationship has come up in so many topics over tonight's webinar, and it's such an important thing because condos are communities and communities are based on relationships. So thanks again for those tips and for pointing that out. Speaking of relationships, you know, we're all stuck home now, and we're 8 weeks into this pandemic, and our patience is wearing thin, and people are becoming noisy, and we're dealing with noises that we haven't heard before. So there's bound to be some more conflicts. And Mark Bala, who's a mediator arbitrator from the Toronto chapter, is going to talk to us about how do we deal with these conflicts during the pandemic. Mark, what are your thoughts?
Thanks, Sonja. Greetings, everyone from the 6 this evening. Nice to have you with us and nice to be here. Just wanted to very quickly, before I answer the question, just clarify the capacity that I'm speaking. I'm speaking based on my personal experience in my private practice of mediation and arbitration. I'm not in any way speaking on behalf of the Condominium Authority Tribunal or the Condominium Authority of Ontario. With that being said, as Devin mentioned earlier on, courts have been closed as a result of this pandemic. Dates that people had scheduled for proceedings to take place have been adjourned, and there's growing concern that even as restrictions are lifted, the already backlogged court system is going to become even more backlogged, making it take even more time to resolve conflict. So what we've found is more and more people are turning to what used to be called alternative dispute resolution. We like to call it dispute resolution in the field now, which is basically mediation and arbitration. The thing is, though, that with physical distancing requirements and gathering restrictions, these processes can't take place in person the way they traditionally have. So instead, what we find is they're taking place online. The thing is, though, that online dispute resolution isn't something that's new, even though it might seem like it is. I have the opportunity to regularly guest lecture at Osgoode Hall Law School on the topic of online dispute resolution, and my presentation is themed in the 90s, complete with Zach Morris cell phones, 5 1/4-inch floppy disks, because it was back in the 90s that online dispute resolution emerged. It emerged, if you think about the World Wide Web booming and new disputes arising about things like domain names that didn't have a natural geographic jurisdiction. In 1995, eBay and Amazon were both formed, changing the face of how international consumer transactions took place. No longer just large numbers, lower value type disputes that don't make sense to spend thousands of dollars and bring in your cousin Vinny to address. Speaking a little bit closer to home and in the realm of CCI Toronto, back in 2015, I had the opportunity to interview a colleague, Colin Brannigan, for a 2-part podcast on online dispute resolution. And back then, when I was speaking with Colm, we acknowledged that while ODR was available, not a lot of people were embracing it. We determined that the reason for that was because a lot of people had a lack of familiarity with how online dispute resolution would work and weren't really sure if it would be legitimate. Fast forward to this pandemic, and what Jim Allison said earlier, this pandemic has accelerated our use of technology. Increasingly, people are gathering with friends, having business meetings through platforms such as the one we're using here tonight. They're getting increasingly comfortable using technology to communicate, and they are able to use these technologies now to help preserve their relationships through dispute resolution. If I had the time, I'd tell you a funny story of when my mother-in-law first started using Facebook and some of the challenges that she had. But it all comes down to what is known as media richness theory, which basically says that the more you become familiar with using a particular platform or medium, the more you perceive it to be robust, the richer you find it to be. It's not a standard, it's not flat, it is variable based on the end user's comfort level. And what we found with this pandemic is more and more people, and I saw a lot of comments here tonight as well, more and more people are being increasingly comfortable having meetings through these types of platforms. And that translates to them being more comfortable embracing the platforms to resolve their disputes and preserve their relationships. The last piece I just wanted to mention is it's important to remember that online dispute resolution isn't simply somebody getting a Zoom account and trying to conduct a mediation. You do need a facilitator that has skills and has experience in how to conduct online mediation and online arbitration to make the most out of the opportunity. There are three particular advantages that I've come across in my practice on online dispute resolution that I just wanted to share with you as I close. Number one is I found that there are opportunities to communicate beyond just video. While I know it was mentioned earlier on that with annual general meetings, you try insofar as possible to mimic what would take place in person, that's not appropriately the case with online mediation or arbitration because there are a lot more opportunities to do things that you can't do online. An example of this is you don't have to just participate by video. A lot of the processes I facilitate use a combination, text, audio, and video, and that helps some people get more comfortable being able to participate because not everybody likes to be on a camera. Second, it's easier to break up the process. No longer do you have to spend 3 or 4 hours in a row attending a mediation because that's the only time it will fit into everybody's schedules and people have to travel to a particular location. Instead, we can break it up into a series of events that take place over days, weeks, and months that I find with condo boards especially make it a lot more advantageous because there's opportunities to check in with the board even though they're not necessarily participating in these processes. Last but not least, I like to take a tip that I actually learned from the Muppets, and it's called travel by map. Essentially, what it comes down to is you're no longer restricted by geography. Unlike lawyers, mediators, and arbitrators aren't limited by jurisdiction of their practice. So what's happening now with people going online is remote areas or areas where you don't necessarily have a practitioner with expertise, you can call them in without it costing that much because they're able to connect with you online. Thank you.
Thanks, Mark. All right, so we've had 9 lawyers, 4 property managers, an owner, a director, a condo industry consultant, a fire safety consultant, and a mediator and arbitrator. And we've got representation from 17 chapters from coast to coast. But a national webinar would not be a national webinar if we didn't hear from our national president. So Stephen Cassidy is here on behalf of CCI National and has a few words to share with us. Stephen?
So I'm going to promise that this is going to be 2 minutes and 43 seconds. And more importantly, this is about a thank you to all of you participating. So hold on here. Today we had an exceptional, superly exceptional group of 17 people who not only live and breathe condominium and strata, but who focus on making people's lives and their communities better. And I say this as the vast majority of these people I have worked with, interacted with, and shared experience with, many of them for over a decade in this organization with CCI. When we made a call to our chapters to ask for assistance in delivering content from a wide range of people, the individuals that you have heard today leapt to the occasion. They offered time and resources, planning, participation to make this work. The results, phenomenal. We sold out our webinar limit of 1,000 people. So seriously, thank you. And I mean this in the spirit. This is what reflects our organization, the Canadian Condominium Institute, that our chapters share a common binding, a belief that every member, you, of CCI can access not only local resources, but resources from across this country. These speakers literally exist to make a world around condominium strata at a federal, provincial, and municipal level better. And okay, so that really sounds like one of those prepared speeches of like, woo, we're the best. And I apologize for that, but I have to tell you, I am overwhelming and brimming with the concept that having been part of this, and it's a small part, seriously, my part's been small, tiny, because compared to those people behind the scenes who have been organizing this and making it work today, it's been phenomenal. It's them pulling together. This has just been great. So look, keeping under the 2 minutes, 43 seconds. Me, the organizers, the speakers, we are pumped. We've been pumped in delivering a national webinar that brings talent from coast to coast. We are excited that we can feed off your direct support of CCI to bring this webinar to you. And that's important. That's the closing part. Feeding off your support of CCI. Thank you. Because without your support through your memberships, your participation in our events, our sponsors, and most importantly, the overwhelming number of owners and board members that are registered tonight for viewing, thank you. Without you, we would have no reason to exist, seriously. We would not have the drive to jump up and leap to this opportunity without you to make condominium and strata better. And you ultimately are what CCI is. So with that, one last sentence. I really do hope that you are all safe and secure as best as we can be expected under the circumstances. Take care.
Thanks, Stephen. And I'd also want to just echo those comments of Stephen's and thank all the speakers tonight for all the time that they took to put this webinar together. Just want to remind everyone about some upcoming events at various chapters across the country. Nova Scotia, May 26th, Living with Your Declaration. CCI London is doing a webinar on May 26th called No Stupid Questions. CCI Huronia is having their regular Tuesday COVID in Condos webinar on May 12th. Eastern Ontario is starting their 4-part director's course June 4th. CCI Toronto just released their new season of Condo Convo. And CCI Grand River has a Leaders Circle webinar on June 9th. Be sure to check out the websites of all of these chapters. There's some great events going on, despite the fact that we can't meet in person. Education is one of the things that keeps us going, and CCI is continuing to educate condo owners and directors and those involved in the industry throughout this pandemic and going on in the future. So until next time, I'm Sonja Hodis. I ask you to please be safe, be patient, be kind, stay home, wash your hands, and let's all work together to crush COVID. From the entire CCI family, from coast to coast to your family, wishing you good health, and we hope to see you soon again.